At our law firm, we often get calls in the middle of the night from somebody who's had a loved one or a family member arrested. This can be a scary time, especially when we don't have enough information about what's happening and we're eager to know what we can do to bring our loved one back home safely. The goal of this video is to navigate you through the process and tell you what information might already be available to you. First, we need to find out the local jail that they're in. And we can do this by trying to identify the last place that your loved one was seen, whether they were alone when they were arrested, and whether or not they have any friends that can tell you the last city that they were in when they were arrested. You can also try to find out if your loved one made a phone call to somebody else to let them know what jail they were in, or if you have access to their iPhone to find their location to find out which facility they're in. Finding out what local jail they're in is the first step to try to get them home back safely. The next step after that is to get their identifying information, specifically not just their full name, but their date of birth, and if possible, what their CEN or PFN number is. The CEN is the criminal event number, and this is a number attached to the alleged crime that they are being accused of, whereas the PFN is a personal filing number, and that is your loved one's ID number in jail. Sometimes a crime can have one CEN number and multiple PFN numbers attached to it, especially if your loved one allegedly committed the crime with other parties or co-defendants. Finding out a CEN or a PFN number will help us get the next piece of information that might be available to us, and that is their bail amount. It's important to note that sometimes your loved one may have a long or hyphenated last name. For example, my full name is Javel Jensen Fuentes Lamano. I might be found in the jail as either Javel Lamano, Jensen Lamano, or my names could be merged into one. For example, Javel Jensen as my first name with no spaces, and Fuentes Lamano as my last name. We want to be diligent about using the different ways that your loved one's name could be spelled. Now that we know what jail that they are housed in, using this information, the goal is to find out what their bail amount is, and there are several ways to do this. One way is to contact a bail bondsman who often have different direct lines to the jails or use their own personal databases to find out this bail amount. Another way is to use online tools such as the Alameda or Contra Costa Inmate Locator or the respective county's online database. We want to use the identifying information that we talked about earlier, including name and date of birth and the different ways that we can use their full name. Another way to look it up is by the attorney calculating what's called a bail schedule. This is basically based on the county and the arresting charges and what the total bail amount is of a crime, considering whether or not your loved one has a prior criminal history, whether there were victims in the crime, and whether there was serious great bodily injury. Sometimes no bail amount will exist because your loved one was either on parole or probation, or the crime that they're being accused of does not hold a bail amount. If there is a bail amount, you do have to consider your financial resources because there's ultimately two ways to post bail. One is to hire a bail bondsman and to pay a fraction of the bail that is not returned to you. For example, if the bail amount is $100,000, you can pay a bail bondsman 7 to 10% of that amount, or $7 to $10,000. The bail bondsman will then post the bail, and your loved one should be out between 6 to 18 hours, depending on the jail backlog. Many bail bond companies do take payment plans, so even though you might not be able to get your loved one out of jail using the full bail amount, you could pay a fraction of the bail in payment plans. If you do this, you don't get your money back from the bail bondsman. In other words, regardless of whether or not the charges are dropped, dismissed, or never even filed, you still owe the money to the bail bondsman. The other way to post bail is to pay the full bail amount to the court. For example, the full 100,000 if you have the financial resources to post that entire amount. It could be less or more of the 100,000, but regardless of what that is, if you have the money to pay the full bail amount, you can get this money back at the end of the case, regardless of the results. For example, if your loved one had the charges dismissed, if the charges were never filed or rejected, you still get that full amount back from the court. The court will hold your money until the case is over or resolved, and it could take weeks, months, or even years if the case is serious. So you have to be comfortable letting that court hold your money until the case is over. What happens if you don't have money for bail? The next thing to do is to find out when your loved one's next court date is. You can get this information through the same information that we talked about earlier, a bail bondsman, an attorney, or online jail databases, or even calling the jail or the court. Once we find out when that court date is, you can actually gather documents to help your loved one in something that's called a bail motion. This is a request from an attorney to the judge to lower your loved one's bail amount or to release them on their own recognizance. This is known as OR. In other words, asking the judge to release your loved one by making the bail amount zero. Some of the documents that could be helpful in this bail motion include proof of employment, proof of residence, a resume, a passport of your loved one to show the court that if he's released or if she is released, that that person won't leave the country and is not a flight risk. We ultimately want to show the judge that your loved one has ties to the community. If the charges are the felony, there are some things that you need to know about, specifically a preliminary hearing. A preliminary hearing is a court date that your loved one has a right to within 10 court days or 60 calendar days of that court date. This is a right that your loved one might want to exercise if they're unable to post bail and they're sitting in jail twiddling their thumbs. A preliminary hearing is like a mini trial. In other words, it's an opportunity for your loved one to present evidence in their case. Now, this situation of having your loved one in jail can be a very scary and difficult time. And while this video does give you information on what you can do to gather information, the best thing for you to do is to call an experienced criminal defense attorney to not just help you navigate the process, but also to help you identify what you can do to get your loved one the best defense. At Lamano Law Office, our goal is to keep you informed. Please give us a call if there's anything that we can do to help, and thank you for listening.